I call the August 13th, 2025 meeting of the Seclusion Working Group to order, and a quorum is present. My name is Senator Judy Seeberger. I'm the chair of this working group, and I want to welcome everyone here to our first working group our first meeting of the Seclusion Working Group. What I'd like to do is go around, have everyone introduce themselves, say a few words about their background, their experience within a Setting 3 and Setting 4 program, what led them to seek appointment onto this working group, and we'll go from there. What I'd like to do first is review some of my expectations with regard to decorum and the topic of this working group. This is a working group on the issue of seclusion. Seclusion is specified in statute as a restrictive procedure to be used in emergencies. We're not talking about disciplinary seclusion. We're not calling it solitary confinement. This is seclusion as defined in the statute as a restrictive procedure when it comes to emergencies. That's the topic of this working group, and that's what we're going to be speaking about. So I know that this can be an important and personal topic for people. I would expect people to treat us all with respect. If we can't do that, I will recess this working group until we can figure out a way to make that happen. So I will start to my left, and we can go around and start there. Just introduce yourself to the group. Let us know what your background is and what led you to seek appointment to this working group. I hate to interrupt you. You're going to see a switch there. Flip that to on. Thanks.
There we go. So school counselor, Minneapolis Public Schools Homeless Highly Mobile Department. I work in all of our high schools supporting our students experiencing homelessness. Prior to that, I worked in Intermediate District 287 for 10 years as a school counselor in South Education Center, which is their Setting 4 building in Richfield. Outside of my work, I support a young mom of 3. I have a DOPA, a Delegation of Parental Authority for the kids, so I help make medical and educational decisions. Her 6-year-old has autism and ADHD, was in a Setting 3 kindergarten last year, and will be starting a Setting 4 first grade in District 287 this fall.
All right, thank you. Next.
Good morning. My name is Dave Haveman. I am the Executive Director of Special Services at Northeast Metro 916 Intermediate School District. It's a mouthful. And we reside in the White Bear Lake area, but we serve, we have programs that go as far west as Circle Pines, as far east as Lake Elmo, and everything in between on the northeast side. This is my second year with Northeast Metro 916 as basically the overseer of the 7 programs that are there. Prior to this, I served for 7 years as the Director of Special Ed in Hastings, 2 years as the Director of Special Ed in Lakeville, and I've served charter schools as a Director of Special Ed as well. And so this is my 29th year in the field of special education administration. What brings me here is prior to last year, I was on the side of the fence where we referred students that needed Fed Setting 4 services in an intermediate to an intermediate as we worked with them as a partner. Now I'm on the side where we're receiving students from 13 member districts, and we are doing the programming for those students. So I have a lot of vested interest in knowing what our tools are going to be and what they're not going to be as we work with students and help them be successful. And I'm learning as I go. This is my second year on this side of on this side of the fence. So it's been a good ride, and I'm hopefully able to add some expertise to the table here. Thank you.
Thank you. Next.
Hi, I'm Brian Rappy. Thank you, Senator Seeberger, for bringing us together for this. Just a point of clarification, are you the chair, or do we refer to you as senator, or how do we best refer to you?
I am the chair. You can refer to me either as Chair Seeberger or Senator Seeberger.
All right. Thank you, Senator. Like I said, my name is Brian Rappy. I have been a teacher and educational assistant in the Burnsville School District. I started off as an educational assistant in a level 3 EBD program and then worked my way into becoming a teacher. I currently teach reading for special education, and I have level 3 students that attend my classroom, but I'm not a level 3 teacher. I'm also the former chair of Pelsby, and that what brought me here is I think I have an understanding of the unique needs of teachers within the licensing structure and in Minnesota, and I really felt my expertise could be helpful with this. Thank you.
All right, thank you. Next.
Hi, everyone. Chair Seeberger, Sue Abderholden. I'm currently the Executive Director of NAMI Minnesota. Have been there, it'll be just about 24 years next month. But I also spent 10 years as the public policy person and then the Executive Director of ARC of Minnesota. Also spent 3 years as one of the assistant directors at Pacer Center. And actually had a foster care license where I provided respite care for children with disabilities who most of them were in level 3 or 4 settings for over a decade. I will also mention that I actually kind of wrote and pushed the bill in the 1980s. Back then we called it aversive and deprivation procedures, ending phoretic skin shock in use in our state hospitals, and pulled together the group in 2008 to write what is now the current legislation that passed in 2009 and went into effect in 2011. So this is an issue that I've worked on for decades, including working with people across the country on this issue as well.
Thank you. Going this way, Representative Engen.
Thank you, Madam Chair. Elliot Engen, and I represent Lionel Lakes, Centerville, Circle Pines, White Bear Township, and North Oaks, some of the communities that you'd said that you're working with as well. So great to meet you. And while I don't really have all that much experience in this, school safety has been something that I've been passionate about in the legislature. And so hearing from you guys, experts in the field, boots on the ground, folks who are doing this day in and day out, I'm excited to learn more from you guys and engage in this discussion. So thank you so much for having me.
Next.
Thank you. Good afternoon, everyone. My name is Samantha Sensumura. I'm the state representative for District 63A, which is a part of South Minneapolis, including part of the Minneapolis Public School District. I am in my second term on the Education Finance Committee, so certainly have had discussions there about this issue. And before coming to the legislature, I worked in public education for about a decade, both in in-school and nonprofit settings. Never worked at a school with a level 3 or 4 program, but kind of come to this topic from some work in restorative justice, as well as work in coordination of services for young people and their families. Thank you.
Thank you. Next.
Thank you, Chair. Jessica Heiser, I'm from Minnesota Disability Law Center, part of Mid-Minnesota Legal Aid. We represent anybody with a disability who has a disability-related issue in the entire state of Minnesota for free. So we get a lot of calls. But prior to that, I've been an education attorney for 13 years. I have represented school districts for the vast majority of that. And started my career as a teacher in low-income schools. So I have only been in education since I left education. Thank you.
Thank you. Next.
Hello, I'm Erin Sandsmark, the Executive Director of Solutions Not Suspensions, Minnesota. We're a nonprofit that focuses on student well-being across the state of Minnesota. We're focused on discipline disparities and making sure that all students have access to school systems that look like them and feel welcoming to them. I come to this as Executive Director of SNS to make sure that the voices of the folks in our coalition that are most subject to the use of seclusion are being represented. Our Black and brown families and our children with disabilities are being represented in the community that has spoken out largely on this issue. And I also come to it personally as a former educator, spending over 5 years off and on in special education classrooms specifically, and in setting 4 and setting 3 settings. So I'm really happy to be here. Thank you.
Thank you, Ms. Sandsmark. And I just want to remind you, we are not talking about seclusion as a disciplinary tool in this working group. This is simply about seclusion as a restrictive procedure in emergencies. All right, next.
Thank you, Chair Seeberger. Good afternoon, everyone. My name is Nicole Woodward. I am currently the Executive Director for the St. Croix River Education District. We're a cooperative unit that serves 6 districts north of the metro area, providing a variety of special ed services and programs and more. And so I'm also the Legislative Tri-Chair for Minnesota Administrators for Special Education, or MACE. So just, really core value of advocacy brings me to this table. creating a bridge for students and families and staff so that we can all find a path forward together. In terms of background, I'm a licensed school psychologist, and I served in that capacity. And then prior to being in public education, I worked for 8 years at an autism therapy center with young children who had significant needs related to autism. And so have a lot of experience intervening with very challenging behaviors and a great passion for supporting students, families, and staff in that context. Thank you for having me.
Thank you. Next.
Thank you, Madam Chair. Good afternoon, everybody. My name is Kate Hulse. I'm going to pull this a little closer. Got a little frog in my throat. My name is Kate Hulse, and I am the Director of Social Emotional Learning for Intermediate District 917. So very much like Dave Haveman over there, I work in the intermediate that serves the South Metro Twin Cities. We're located almost entirely within Dakota County. We do have one district, Bloomington, with that is within Hennepin County, but otherwise we serve kind of that South Metro suburban and exurban area. We serve the students that frankly cannot be served in typical public school settings due to the needs that they have, and often those are behavioral needs. I am also, like Nicole, a school psychologist by training. Went into work as an administrator about 10 years ago. I myself have been working in setting 3 and setting 4 for over 15 years. 14 of those 15 have been in setting 4. Many of those were kind of in boots on the ground type of roles, and then I've been purely administrative for, say, the last 8 or so. I'm also married to someone who is still boots on the ground in setting 4 and who has worked in setting 3 and setting 4 for 18 years. And so the discussions at my house daily are about student safety, staff safety, and really what things look like when people that perhaps don't fully understand what these procedures look like or what the behaviors that precede these procedures look like get made without the input of the folks that are kind of live in the day-to-day. So I feel very honored to be a part of this discussion, and that is really why I advocated to be here at the table. So thank you for including me.
Thank you. We'll go online. Let's see, who do we have first? Okay. And I'm learning we may have some technical difficulties preventing our folks online from hearing what we're doing. So we're going to wait for just a second.
Test, test. Testing.
All right, I'm going to call a brief recess while we get this figured out, and then we'll come back once we get our technology sorted. Sounds like we got everything worked out, so we will reconvene this meeting of the Seclusion Working Group. All right, next online, we will have Senator Julia Coleman introduce herself to the group, explain your interest in the topic and what sought your appointment here to the Seclusion Working Group.
Can everyone hear me okay?
We can hear you, thanks.
Awesome. Well, hi, everyone. My name is Julia Coleman. I'm representing Senate District 48, which is Waconia East through Chanhassen. I'm also the Republican lead on education policy, which is why this was of particular interest in me, for me, because it's come up so many times in committee. And I asked, I wasn't voluntold, I asked to be on this because it's just such an important topic. And I look forward to hearing everybody's perspective and working with you all. So thanks so much.
Thank you, Senator. And for the benefit of our online participants who did not hear the beginning of this meeting, I would like to emphasize that this working group has been convened to discuss seclusion as a restrictive procedure in an emergency, not as discipline. We're not going to be talking about any disciplinary use of seclusion. That's not the purpose of this working group, nor are we going to be referring to it as solitary confinement. So I would ask comments be confined to, limited to the topic of seclusion as a restrictive procedure in an emergency situation. Our next person online will be Kim Baker.
Hi, my name is Kim Baker. I'm the Assistant Director of Special Services for the Owatonna School District. That's District 761. I'm also a parent of children with special needs, and I serve on the school board in Lakeville Schools. That's District 194. So I work with seclusion in a personal and professional manner. So I'm very interested and happy to serve on this board to help us make practices that work best for students.
Thank you, Ms. Baker. I haven't met you. I briefly went around and introduced myself to the folks that were here. You are with you're the Assistant Director of Special Services with the Owatonna School District?
Yes, that's correct.
All right. And does Owatonna provide Setting 3 or Setting 4 services to its students?
Setting 3.
And is it K through 12 Setting 3?
Yes.
Okay. Thank you. And we have Maren Christensen. If you could unmute your mic and introduce yourself to the working group.
Thank you very much. My name is Maren Christensen Hofer, and I'm actually standing in for my colleague Fatima Molas, who is a member of the work group. She was unable to attend today, but she asked if I could attend in her place. And we both work for a nonprofit organization called the Multicultural Autism Action Network, which serves families of children with disabilities. And I'm also the parent of a child with a disability myself.
Thank you, Ms. Christensen. And what is your experience with students in a Setting 3 or Setting 4 program?
So we serve as advocates for families of children with disabilities, many of whom are in federal Setting 3 and 4, many of whom have experienced seclusion. My own child has experienced seclusion. And I also served as a member of the Restrictive Procedures Work Group that was organized under the Department of Education since, I think, 2019 until it was disbanded in 2024.
Okay, thank you. All right, and I will introduce myself. My name is Senator Judy Seeberger. I represent District 41, which is on the east side of the metro. I am a licensed middle school and high school English teacher, having spent 10 years in the classroom. The reason I got my teaching license and master's in teaching was because I had a son that I wasn't sure would make it through the public school system. And I wanted to be able to make sure that if I had to homeschool him or the responsibility for teaching my son fell to me, I wanted to at least have the background and the knowledge of how do I teach. I have emerged, and I'm sure all the educators in the room will agree with me, but I have emerged from that program with the firm belief that not everyone can teach. Just because you know a subject doesn't mean you can teach a subject. I think it takes a special craft, desire, passion, and an ability to connect with students to be able to be a classroom educator. And that's what I did. I got in the classroom and I loved it. And I think we all know that there are plenty of general education students who maybe should receive special education services, but for whatever reason, those aren't available to them. So my area of special interest was in students with challenging behaviors or students that other teachers found challenging to have in their classroom. I mentioned my son. My son is now 20. But he spent the majority of his educational experience in a setting 3 or a setting 4. He's a big guy. He's always been a big guy. And his particular challenge was emotional regulation. And when he was severely dysregulated, he would aggress toward adults. So I remember being concerned as a young mother with a young kid entering kindergarten. How's this going to work? How's this going to work in school? Because these behaviors are things that I don't know a whole lot about. This is baffling to me as a parent. How is this going to work in a school situation? There were years we never left the house because his behaviors were not under good control. We couldn't go to the restaurant. We couldn't go to Target. We had to stay home and supervise him to ensure that he didn't hurt himself, he didn't hurt us, and he didn't destroy the house. So when I went on a school tour of a setting 3 school when he was in first grade, and I saw the room where kids go, the seclusion room, I breathed a sigh of relief. There's going to be a safe place for my son and for the staff when he gets dysregulated. When he was in second grade, in one of his behavioral outbursts, he broke a parent's thumb. And those things stay with me and are what I think about when we talk about things like banning seclusion up to grade 3, banning seclusion altogether, and it concerns me. And that's why we've convened this working group, to hear all different perspectives of what it's like both to be the parent of a child with significant needs, to be a teacher in a setting 3 or a setting 4, to be a special ed director that deals with this population, so that we can have informed, educated conversation about this topic, which I think sometimes has been lacking when we've addressed this issue. My son was in a setting 4 up until he was in about 9th grade, and through all the work that we put in, and a huge shout out to 916 who provided the services to him, Stillwater School District who was amazing, he managed to graduate at a setting 2. So very pleased that we got him through, but it was advanced parenting. I always say I have 2.5 kids because he was worth it, but a lot of work. But that's where I come at from this topic. That's the perspective I come at. And I want to honor everyone's experiences when it comes to their own child's education, their own child's experience, and each family's experience when it comes to their educational experience and the things that they've encountered. One other story I'm going to tell, my son was not always put in seclusion when he needed to be. One time he was not, and that time he was arrested. He was 11 years old. He was in 5th grade. And he went to Ramsey County Juvenile Detention. It was a Friday. The only reason they were able to let him out, I went down to get him, the only reason they were able to let him out was because they needed the space, and I was one of the few parents to show up and claim their kid. He was in the juvenile justice system for 1.5 years. And during that time, in order to be let out of prison, jail, one of the terms of his release was no same or similars. His whole life was same or similars. So if he aggressed towards someone again, they were going to put him back in juvenile detention. So what that meant for us as a family is we had to back off of a lot of behavioral interventions, because as we all know, sometimes when you support a kid and push a kid, behaviors will often get worse before they get better when they reach that next plateau. And it was a 1.5 years of lost ground getting him disentangled from the juvenile justice system. It was a 1.5 years of essentially what it felt like letting him get away with whatever he wanted, because we could not afford another same or similar, another episode or outburst that would lead to his reincarceration in the juvenile detention system. So my fear is, and a baseline for me, is if we take away a tool that a school has within their toolbox to use in emergency situations, we are inviting law enforcement in as a last resort to control a situation, and we are now feeding the school-to-prison pipeline. And I'd be happy to have an additional conversation with anyone to tell you more about how detrimental this was to my family at 11 years old, to be incarcerated. So this is my interest in the topic. This is why I feel very strongly about having this working group, and I'm really grateful that we have this opportunity to come together and speak plainly about this topic, and hopefully have some good information to report back to the legislature when we're done. So I think what I want to do now is turn it over to Andrew George from LCC Research to go over the enabling legislation and open meeting law when it comes to this particular work group. And then we're going to go through the existing statute on the use of restrictive procedures. So, Mr. George, I turn it over to you.
Thank you, Madam Chair and members. Hi, everyone. My name is Andrew George. I'm a nonpartisan staff with the Legislative Coordinating Commission. The LCC is helping administrate this task force. You have received emails from me. I'll be helping schedule these meetings, conduct research, and work with the chair and all of you to help develop meeting agendas, and we'll write the report to the legislature at the end. I'm joined by some commission admin assistant. Mina Zhang will be, you'll also be receiving emails from for other scheduling things and things like that. I'm going to walk through the enabling legislation for everyone and members of the public, and our members online can find this on the task force or the working group's website as well. All right. The Seclusion Working Group was established to evaluate the use of seclusion as an emergency procedure and not as discipline, as required in Minnesota Statutes, Section 125A.0942, Subdivision 3. I can see. Oh, it's nipped. There it is. There are 16 members of the working group. There are 4 legislative appointments, 2 members of the Senate, 1 appointed by the Senate Majority Leader and 1 appointed by the Senate Minority Leader, and 2 members of the House, 1 appointed by the Speaker, 1 appointed by the DFL caucus. There are 12 joint legislative appointments who represent the following groups: special education directors from the Setting 3 or 4 program, cooperative, typo there, cooperatives under Minnesota Statutes, Section 123A.24, provide special education instruction, parents of family or students who have been secluded, teachers who work with students in a Setting 3 or 4 program, paraprofessionals who work with students in a Setting 3 or 4 program, licensed school psychologists or school counselors who work with students in a Setting 3 or 4 program, and organizations that represent students who are disproportionately affected by the use of restrictive procedures. There are 8 duties of the working group. The first is to evaluate the effectiveness of seclusion compared to other methods of restrictive procedures used in emergency situations on different age groups and in different educational settings, to analyze how the lack of alternatives to seclusion forces children and their families to interact with the criminal justice system, to evaluate workable alternatives to seclusion, to consider the effects of seclusion on children's mental health, access to a free and appropriate public education, academic outcomes, and overall well-being. Oop, I went the wrong way. to identify new and existing resources necessary for staff capacity and training, children's supports, child mental health services, and school-wide collaborative efforts, to visit school sites that currently use seclusion, to review applicable laws defining and regulating seclusion in schools, and then ultimately to report its findings and recommendations regarding the use of seclusion to the chairs and ranking members of the education committees, no later than January 30th of 2026. For the chair, administration, and consultation, the member appointed by the Senate Majority Leader is going to convene the first meeting on or before August 15th. We must meet, the working group must meet monthly and be open to the public. The Legislative Coordinating Commission will provide meeting space, technical administrative support, and staff. And the working group must consult with the Department of Education and Department of Human Services, including a representative from the Department of Human Services, specializing in school-linked mental health. Finally, the working group will expire on January 31st or when the final report is submitted to the legislature, whichever is later. That is my walkthrough, Madam Chair, of the enabling legislation. I can move on to the open meeting law, or I can take questions here.
Thank you, Mr. George. Are there any questions for Mr. George at this time regarding the enabling legislation? All right, seeing none, we will move on.
Thank you. Members, in your packets and then online for our public members, as a legislative subdivision, the Seclusion Working Group, we have a memo titled Legislative Open Meeting Law Memorandum. As a legislative subdivision, the Seclusion Working Group should abide by the Legislative Open Meeting Law. That's section 3.055, which provides that meetings shall be open to the public and defines a meeting as any instance where a quorum is present and action is taken regarding a matter within the jurisdiction of the body. This group has 16 members. Under the legislative opening meeting law, then a quorum would be 9 members. If subcommittees are established, a quorum is the majority of that smaller group. Further, a member participating in a meeting via interactive technology is considered present at the meeting for purposes of determining a quorum. I'll just finally advise members to avoid meeting and discussing issues within the jurisdiction of the group outside of formal, publicly announced and open to the public meetings. And that would include like email chains and things like that, just to stay on the good side of the open meeting law. You'll have the open meeting law in your packet as well, and that's the open meeting law.
Thank you. And again, I think where people oftentimes get tripped up on this is in email communications, email chains, that kind of thing. So we'll do our best to be cognizant of the open meeting laws and not engage in that kind of communication. And in your packets, we have a summary of the restrictive procedures statutes that Mr. George will walk us through at kind of a high level. Mr. George?
Thank you, Madam Chair and members. In your packet, you'll also find a research memo from Senate Council regarding current statute around restrictive procedures. I'm just going to do a high-level walkthrough of it. And go through the definitions. This is current statute regarding restrictive procedures is section 125A.0941, and it defines several terms related to restrictive procedures. Restrictive procedures is defined as the use of physical holding or seclusion in an emergency. It prohibits the use of restrictive procedures as punishment or discipline. Physical holding is defined as a physical intervention intended to hold a child immobile or limit a child's movement, where body contact is the only source of physical restraint, and where immobilization is used to effectively gain control of a child in order to protect a child or another individual from physical harm. And then gives a list of what physical holding is not. The definition for seclusion farther down is defined as confining a child alone in a room from which egress is barred. Egress may be barred by an adult locking or closing the door in the room or preventing the child from leaving the room. Seclusion is not removing a child from an activity to a location where the child cannot participate in or observe the activity. Later, the definition for emergency is defined as a situation where immediate intervention is needed to protect a child or other individual from physical injury. Then later on, it gives standards for restrictive procedures, including restrictive procedures plans, the use of restrictive procedures. And then I'll go into number 3 there on page 3, physical holding or seclusion. Physical holding or seclusion must comply with the following requirements. 6 requirements: used only in an emergency and the least intrusive intervention to respond to the emergency, cannot be used for discipline. Holding or seclusion must end with the threat of harm ends, requires constant staff observation, detailed staff incident reporting, and seclusion room requirements include observation, window size, lighting, ventilation, compliance with building fire and safety codes, and registration with the Commissioner of Education. There are, number 4 there on page 3 also lists several prohibited actions in terms of restrictive procedures. 5 also goes into staff training that must be required for staff persons at schools who use restrictive procedures and what they must be trained in. That, Madam Chair, is the high-level walkthrough of the current statute on restrictive procedures.
Thank you, Mr. George. I would encourage our members to review Minnesota Statutes 125A.0941 and 125A.0942 for details with regard to the use of restrictive procedures. But what I wanted to do was highlight the definition of emergency before we move on. And I'm going to read it verbatim as it reads in Minnesota Statute 125A.0941, sub B. Emergency means a situation where immediate intervention is needed to protect a child or other individual from physical injury. Emergency does not mean circumstances such as a child who does not respond to a task or request and instead places his or her head on a desk or hides under a desk or a table. A child who does not respond to a staff person's request unless failing to respond would result in physical injury to the child or another individual. Or an emergency incident has already occurred and no threat of physical injury currently exists. And the reason I wanted to highlight that definition is because while I was not involved in drafting this language, it seems to me there was a fair amount of thought that went into it on what an emergency is and is not. I don't often see examples given in definitions that exist in statute, but there are examples here, and to me that speaks to just what we're trying to get at here, and that is to protect a child or other individual from physical injury. So this is the context in which we are couching our discussion of seclusion. Before we move on, I'd like to open it up to members of the working group for any comments on the enabling legislation, 125A.0941 or 0942. If there are any questions or comments on things that we've covered so far.
Madam Chair, I do just want to briefly comment in gratitude on the distinction you've made from the start around what we're talking about. I know I speak on behalf of myself and surely some of my fellow educators who I work closely with that we really are here to talk about emergency procedures. And there is no one that I represent or work with who is wanting to discuss the topic of seclusion in regards to discipline. And I think that is often where we get stuck in these conversations, is not being clear that we are talking about imminent threat of harm to self or others. So I just wanted to acknowledge that I really appreciate you making that distinction and the distinction in us reviewing the statute.
Thank you, Ms. Woodward. I will comment that when I had a meeting with Commissioner Willie Jett, he spoke about seclusion. He started speaking about the disparate use of discipline on non-white students, and I had to stop him and say, that's not what we're talking about. We're talking about seclusion as an emergency, as a restrictive procedure in an emergency. So it's, if the Commissioner of Education is not always clear on those terms or confusing the issues, that's a driver as to why I wanted to make sure that we were focused on the right issue here during this working group. Does anyone else want to comment? Ms. Abder-Holden.
Just because of my long history on this issue, I just wanted to say that, when we did the working group back in 2008, what we found is a very different perspective depending on the disability. So I knew in my work at ARC that these procedures were used to actually change behavior. That's what we called them, aversive and deprivation procedures. But in the children's mental health system, it was used for an emergency. And so we had two groups kind of coming at it from different experiences with these procedures. When we initially passed the legislation, it was pared down quite a bit. At the time, school districts were afraid about all the reporting requirements and things like that, so some of that wasn't included in the beginning. Those examples were put in because that's what we saw despite the law being passed, and we said we want to make it clear that those are not emergencies. And so, over time, this law has changed and been updated based on people's experiences. I will also say that and I was on the department's working group all those years, and we would come with recommendations. For example, increased dollars for school linked mental health, especially starting early. And, as you know, we're not in all the schools yet. So there were solutions that were put forward that were never actually part of the Department of Ed's budget. And I will also say that many of us actually objected to the working group ending last December because we had a long history of working together and trying to move forward with changes as well. So just wanted to offer that perspective.
Thank you. And I'm grateful that you're a part of this working group with your long history on this issue. Sad to see you go. Ms. Abder-Holden is retiring from her position here in a few months, and we're grateful that we have you for your last few days and weeks in your current role. Any other questions or comments on the material that we've covered so far?
Chair.
Ms. Heiser.
Thank you, Chair. To just piggyback off of Sue's point too, I just want to point to the enabling legislation, and it says to evaluate the effectiveness of seclusion compared to other methods. There is a bevy of data that MDE and the Restrictive Procedures Working Group has been compiling over the last 10 plus years, 15 years, Sue, you're going to have to correct me there, and that the legislature has put lots of money behind. We've got reports that have been worth $20,000, $30,000 every time MDE has done it. So I just really want to encourage us that we don't need to recreate the wheel. There's a lot of data that we can pull from that we've already put a lot of time and money into. And I want to make sure that we all not only have access to that data, but that we are really utilizing the data that we've already asked for schools and MDE to provide to us.
Thank you. Anyone else? Ms. Holsey. Thanks.
It's Hulse. Thank you, Madam Chair. I would be remiss if I didn't recognize that on the equity point, setting 3 and setting 4, as we know, are already, it's where we see the most inequity, right? There's inequity baked into special education, particularly EBD criteria in this state. And so once we get to setting 3 and setting 4, we see a higher than, yes, proportionate, thank you, a number of, tend to be black and brown males. And so that data tends to show up in our restrictive procedures numbers as well. I think there's absolutely a place to talk about where equity fits within our restrictive procedures numbers, and we need to be continuing to have those conversations in the classroom, at the district level, and at the state level. And I too appreciate the distinction that you made with the commissioner and with what we're trying to do here. That exists, and we can have this conversation here. Both things can be true and are true.
Thank you, Ms. Holson. You bring up a really good point. The disparity, and I would say the disproportionate representation of our black and brown students in setting 3 and setting 4 programs. And I think I don't know that there's been enough discussion on that point to try to identify how we can do better in that regard. So I would challenge us during our work here in this working group that we take that into consideration as well. I think the goal here in issuing a report to the legislature is to make recommendations ultimately that the various committees will take up and that the legislature will take up. And if we can identify areas of opportunity and things where we can act, and I say we as a legislature, to combat some of the disparities and inequities within our educational system, that is our job and that is our duty. And so I'm looking forward to a good conversation on all of those points. Ms. Sandmark.
Thank you, Chair. I just had a question because I completely understand that we are focused on the restrictive procedure in emergency situations on seclusion, of course. And I appreciate grounding our conversation in that restrictive procedure and the reasons for it and what an emergency is. I'm curious if this body will also discuss when the restrictive procedures are used inappropriately. And that's what I'm curious about as well. So I'm asking that of you.
As we look at our duties, I just want to get that in front of me. So what we will be discussing and what we are directed to discuss are the duties that are set forth on the handout that you have in front of you. The effectiveness of seclusion compared to other methods, how lack of alternatives force children to interact with the criminal justice system, workable alternatives, effects of seclusion on children's mental health, access to a free and appropriate education, academic outcomes, and overall well-being, identify new and existing resources, visit school sites, review applicable laws, and report our findings. Those are our duties. We are not here to, again, talk about seclusion used as discipline. We're not here to talk, because that's not permitted under the statute as it is and hasn't been for quite some time. So our marching orders are as set forth within the duties. Okay. Ms. Woodward.
Chair Seeberger, thank you. I wanted to comment in terms of, when I look at our duties and we talk about that, because that concern often comes up when we're discussing this topic. And it does happen. There is inappropriate use of the restrictive procedures we are allowed to use right now in K-3. And I think that really anchors in number 7, where we discuss the review of applicable laws and regulations, or defining and regulating, seclusion in schools. What does that regulation look like? What are those laws? What is oversight? I think that fits there when we have this conversation. So I just wanted to acknowledge a connection that I see to your question and our duties. Thank you.
That's helpful. Thank you. Ms. Abderholden.
I just want to kind of go back to the issue of disproportionality, and it is really related to the EBD criteria. And if we could blow it up, frankly, I would. I would. We've always hoped when they finally open up, IDEA back up again, that we would change that. One of the things that we've seen over time is that families who are, frankly, have means, make sure their kid goes in other health disability instead of the EBD classroom, and that we also saw a lot of confusion among families thinking that their child had a diagnosis because EBD is so similar to emotional disturbance in the Children's Mental Health Act, which was changed this session. Now it's going to say mental illness, so at least we won't have those confusing terms. But we have seen, when kids can't get access to mental health care, it is problematic. But I do think the EBD category, it's where kids sometimes, have been dumped, and especially in high poverty schools, and then that leads to more kids being, in level 3 and 4 settings. And so at some point that issue has to be addressed too.
That's really useful input. Thank you. Any other comments from members? All right. I believe Mr. George sent out a preliminary meeting schedule. Did you do that? Oh, he didn't do that. That's fine. So we, our enacting legislation directs us to meet monthly, and we have identified Wednesdays, once a month, from 2 to 4 in this room, when we will be meeting. But I would like to have our members think about and come prepared to discuss at the next meeting whether we feel like additional meetings would be useful, if once a month is sufficient, or additional things that perhaps members would like to see us do during this time. I would like to, I had envisioned some school visits to see seclusion rooms and school setup where seclusion is used. The LCC is still trying to figure out if that comports with open meeting laws or not. But I certainly, if nothing else, we can see some video footage and things like that of other school settings. So that is part of what I think initially we would like to cover. But I'd like our members to come prepared to our next meeting to discuss how frequently you'd like to meet. I can't find my list. Our next meeting is scheduled for September 17th from 2 to 4. We have reserved October 15th, November 19th, December 17th, and January 14th, all from 2 to 4 in this room. So our members can make a note of that on their calendars and at least hold the space and the time.
Madam Chair, would you repeat those just one more time, please?
Yes, our next meeting will be September 17th from 2 to 4 in this room. Then October 15th, November 19th, December 17th, and January 14th. Because if you're like me, unless it's on the calendar now, you're in a world of hurt.
Madam Chair.
Mr. Rappy.
Yeah, just jumping back to the open meeting law and the site visits, would that, with the open meeting laws, would that, my concern would be the privacy of the students also.
Right, that's part of the issue that we're exploring. So certainly there would not be open site visits that anyone in the public could come. So the concern obviously is protecting privacy of the students, educational integrity, security of the schools, and that's what we're sorting out. Representative.
Thank you, Madam Chair. And on the point about going to, I see that in the legislation it designates that we're supposed to see schools that use seclusion rooms. I'm wondering about once we kind of get the open meeting laws, and if we are able to do site visits, the ability to visit, schools or settings that also don't use them, to kind of be able to contrast and compare. And if we are not able to actually physically go out to those settings, if we would be able to take testimony from various school settings and that use different procedures. Thank you.
Yes, thank you. I think that does fit within the purview of our duties to speak about alternatives to the use of seclusion. So that would certainly be within the purview of what we would do. And kind of on that note, you sort of beat me to the punch here. I'd like to open it up to our members if there's any desired presentations or testimony or topics you would like to cover that we can start kind of fitting into our schedule as we move forward. Ms. Hulse.
Yeah, Mr. Haveman and I in our district have been implementing UKERU, which is kind of sweeping from East Coast to West Coast. It's a newer thing in Minnesota within the last 3 years. It is a non-restrictive crisis intervention approach that uses body positioning and blocking pads. It's not meant to replace restrictive procedures. However, it's meant to be kind of a shortstop and hopefully a deterrent. And it's something that we piloted at 917 last year in a handful of programs to great success. We saw a pretty significant drop in some of our restrictive procedures in the programs where it was utilized. And I know Dave and his folks started piloting mid-year. I would love to bring in some of our trainers and some of the equipment if this group would be open to that. we are really, really excited about it, and we are in the midst of an expansion, and we're going district-wide with it. It's an expensive implementation at the front end, but it's a less expensive maintenance approach long-term.
And I think, thank you, Ms. Holtz. I think I saw this at Cedar Ridge. Is this the blue mats? Is that part of the whole? Yeah. It's UKARU, U-K-R-A-R-U?
UKERU, U-K-E-R-U.
Yep.
I think that's a great idea. Thanks. Well, we will build that into the schedule. And would you be interested in leading the presentation on that, or?
If it please the chair. Our lead trainer, Justin Holscher, is actually on the Pelsby board. And so if we trust him to come in, and if that isn't a conflict of interest in any way, I would love to have him be the guy.
Got it.
And,
thank you.
And if we're partnering together on that, we have a lead behavior analyst,
Yes.
and we're working as a cohort this year with 917 as we partner together on the rollout of this from a pilot into full implementation. I'd love to have her be a part of that with Justin if possible.
That sounds great. So what I'm going to do is ask you folks to connect with Mr. George.
That'd be great.
With your suggestions, and he will facilitate getting that on the agenda.
Great. Thank you. Thanks.
Thanks, Kate.
Any other suggestions on presentation? Ms. Abderholden.
I think it would be good to have one of the school-linked mental health programs that's in an intermediate district to talk about how that has also helped reduce the use of seclusion restraints. And I'm trying to, is it 287 or 916? I forget which one.
We use Canvas Health as one of our school-linked partners at 916.
Okay, and then there's one that uses Wilder.
287, I believe, at this point is using Wilder.
Okay, because of the diversity of their staff in particular, I was thinking.
Great. So we have schooling mental health programs in intermediate districts. Okay, I think that's a great suggestion also.
Madam Chair?
Yes, Mr. Rappy.
Under like the identifying new and existing resources necessary for staff capacity, could we, I would hope we can include the instruction, include in this discussion how staff is treated after an emergency procedure. As you were telling your story, I was reminded a lot of times where I've had to put students in seclusion, then expected to go straight back to teaching class, and I was not prepared or ready to teach class at that time. So if we can include that in the discussion, I'd appreciate it.
So are you talking about use of seclusion in like a general ed setting 1 or setting 2?
More of a setting 3.
Okay, so maybe on a greater level staff supports or support for staff who may have to use certain restrictive procedures?
Correct, that's perfectly defines it.
Okay.
Thank you.
I think that sounds great, thank you. Other suggestions?
Senator Seeberger, I'm
Ms.
trying
Woodward.
to, yes, thank you, sorry. Trying to find the best connection here. But if we are to evaluate the effectiveness of seclusion compared to other methods in different settings, if we're to analyze how the lack of alternatives, forces children and families into the criminal justice system, and I'm thinking about identifying new and existing resources necessary for staff. I really think that hearing some voices of staff who are having to intervene in emergency situations without this tool is very important. That is a lens that I am bringing, having to support staff through some very substantial and serious injuries in the last year plus, including broken bones and traumatic brain injuries and things like that. I think that voice is also very important, and potentially that of a school resource officer who is needing to come in and intervene because there aren't other alternatives, which we've also experienced in my system. So those are two lenses that I think are important.
I would tend to agree. If I could ask you to follow up with Mr. George with contact information to flesh out that idea a little bit better, that would be useful. Ms. Heiser.
Oh, thank you, Chair. Like such great ideas all around. And I'm not just saying that. I really am like, I want to hear from all of these people. I would add two different groups I would love to hear from. We've not talked about the children. We've not talked about the students who have been secluded in an emergency or their families. And I know I appreciate Senator Seeberger's lived experience, but I'd like to hear from more as well. And then the other one I wanted to point out, and I'm so glad we're bringing up this idea and this perspective of the staff who have been harmed and the staff who have not been able to process their own trauma after going through a seclusion. Like I said, I represent schools for many, many years. That's a very real problem. I'd also like to hear from staff who have transitioned, who have been in a school who've transitioned away from seclusion. The school that came to mind for me was a level 3 setting in Minneapolis, Spiro Academy, where they've completely transitioned away from using seclusion rooms. And so they are very much boots on the ground and have been through this transition. And I would love to hear their staff perspectives of before and after and what challenges or successes they've had in that transition.
I think those are all great ideas.
Madam Chair?
Ms. Abderholden.
Could I just add on to what you said? Because I was at a meeting, I don't know, it was about a year ago, where people were sharing their experiences, but it was before this law was passed. And so I want to make sure that we are using stories that are more recent and that, you know, they were operating in under this statute, because it's different, right? Someone who was put in there for, which is why we passed the statute, right? But someone who was put in there for 6 hours, you couldn't do that now. So I just want to make sure that we're hearing newer stories.
And that's a great point of clarification. If we are going to be hearing personal experiences, they do need to be relevant to what we're talking about. So if it is seclusion used as discipline, I hosted a meeting last summer when we were working on this, and someone came in and kind of, maybe some of you were part of this Zoom meeting, took over the conversation and talked about his experience in solitary confinement in prison. That's not what we're talking about here. We're talking about the use of seclusion as a restrictive procedure in an emergency under the statute as it exists. So if we could, I would certainly welcome all perspectives when it comes to that. But what I will not have is testimony or people sharing experiences, traumatic and harmful as they may be, that are not within the purview of this statute. Does that make sense? Okay.
Madam Chair, can I ask for recognition online? I've had my hand raised and I'm not sure that anybody's noticed.
Thanks. We see you. Yes, go ahead.
So one of the things that Owatonna is using is life-based crisis intervention. It's through Teach to Heal. It's trauma-informed practices. We use it in all of our level 3 programs, and we've also transitioned that program into the level 4s that we send students to. We've had great success with that. We don't use seclusion rooms, and we've seen a lot of our students actually transition out of EBD programs into setting 2 and 1 quite successfully. I would say my elementary programs, I have it split into a K2 and a 3-5 room. By the 3rd through 5th grade, if they've been in the program, a lot of times they just don't need it anymore. So anyway, I think it would be something that would be good for the board to hear about that program and how it works and how we talk kids through intervention. We have behavior interventionists in all of our buildings that work individually with students during the time when they're experiencing a crisis. And we have lowered our rates of students that actually use restrictive procedures. We're not really needing them as much as we have in the past. So I think that would be a great presentation that would be beneficial for this committee.
That sounds great. What was the name of the program?
It's through Teach to Heal. It's life-based crisis intervention. We have the majority of our gen ed, special ed, and behavior interventionists and paras trained within our district on that. Our trainer for that has been Danielle Tice. She has her own company. It's called Teach to Heal. And it's something that it's been used in multiple states. A lot of districts in Minnesota have it too. But I think she would be someone that I would reach out to and just have that presentation on, because it's been changing for our district. perspective changing and trauma-informed practice on how we talk about kids, how we team around kids and discuss the things that they're struggling with, and how we do interventions with our students.
That sounds great. Can I ask you to follow up with Mr. George with the details on that, and we can get that presentation on our agenda?
Absolutely, I would love to do that. Thank you.
And Ms. Christensen, I see you have your hand up.
Thank you very much, Madam Chair. I just wanted to come back and emphasize the importance of hearing from students that have experienced seclusion, and just to get some clarity. I think one of the most concerning things that we hear as advocates is that despite what the statute says, that's not actually how seclusion is being used in many schools. So I think it would be important to hear those stories of students that have been secluded repeatedly and for extended period of times, and not necessarily as a emotional regulation tool, because that's the reality of what is happening in many of those cases. So I just wanted to get a little bit of clarity around that. I do think it's important to hear that student voice and allow students to speak to what they've actually experienced.
To seek some clarity, are you speaking specifically to students for which seclusion was misused or improperly used under the statute?
Yes, we have worked with many families who experienced multiple seclusions for extended periods of time where it was not an immediate risk of safety or harm. That's just what was happening to the student, and that's been within the last 2 years.
And which school districts would this be through?
There are multiple school districts where this has happened.
I guess I would be interested in learning more on a macro level where seclusion is not being used appropriately. I think we would all agree on this working group that the inappropriate use of seclusion is harmful for students. That's why the law is written the way it is. So I think my starting point would be maybe someone who could offer testimony with regard to specific districts or places where it's not being applied appropriately, to lead to a discussion on how we can better support them to use seclusion appropriately. I don't see any value in hearing at this point the stories of where it's been misused, because I think we can all agree that that's completely inappropriate and would be damaging to any student.
I'm sorry, would you be so kind as to repeat that? I'm not quite sure I caught what you were saying. You're saying it isn't appropriate to have stories from students where the law has been used inappropriately?
I'm not sure that that would fulfill our direction here within the working group. However, I would be willing to and receptive to testimony specifically to districts or examples where it's not being utilized appropriately, so that we can, as a legislature, or make some recommendations to the legislature to offer additional supports so that they can come into compliance.
Thank you for that clarification. As I understood it, part of our charge is to look at the effectiveness of seclusion, and if it's not being used in ways that are provided for under the statute, I mean, isn't that part of what we're supposed to be looking at here?
Ms. Christensen, I'm reviewing the duties of the working group. Hang on just a second. I do see one of our duties is to identify new and existing resources necessary for staff capacity and training. Again, to the extent that schools are not using restrictive procedures appropriately, and additional training or staff would be useful. I could see us having a conversation within the purview of that particular duty. But I don't know that hearing stories of how it impacts a student when a restrictive procedure is not used according to statute, I think we can all agree that that's inappropriate and incredibly damaging and harmful to the student, to the family, to everyone involved. My aim would be to find out why that's happening and how we can support that school so that it doesn't continue to happen. I'm going to turn to Mr. I can't see your name. Yes, Heyman, go ahead.
Thank you, Madam Chair. I'm hoping, as we talked about earlier, that the tour, or maybe more than one tour, can happen. And if so, we'd be happy to host at 916, and we've done that before with some folks. If that's not able to happen with open meeting law or other logistics involved, I'm wondering if bringing the tour to this group could happen with some of the folks from our end. And so I think about when we've led those tours, when I look at Section 5 of the enabled law here, when it comes to the staff training, we'd love to be able to explain the continuum of supports that we have to help students feel successful, from the proactive things to the reactive things that we have in our plan, and the way that we interact with students throughout the day and as they are escalated or de-escalated. So we're explaining how we not try to go hands-on with students, how do we try to avoid seclusion, but also how we keep things like contraindications involved or in the discussion when we're developing positive behavior intervention plans, and the things that take into account trauma and trauma-informed practices and the way that we train staff as well. So, I mean, we're hosting staff trainings this week, like many other districts are. We do 8 days of staff training for every employee, including paraprofessionals, every single month. And that includes some of the things that we're talking about here in that list of the 8 things that are on this list of ways that we are supposed to train staff. We would love to be able to explain how we try to avoid getting to emergency situations.
And I think that's a great idea. And if we are able to tour facilities, schools, different settings, that obviously will be a part of the conversation of sort of how do we get to where we finally end up if it is, if we do need to use seclusion. But I like your idea of bringing the school to us to see, and that's something that Mr. George and I had talked about as we were trying to figure out the open meeting law piece of this. But thank you for that offer. I think that's a great idea. Okay, Ms. Woodward.
Thank you, Senator Seeberger. I wanted to connect to Marin's comment around inappropriate use of seclusion. And again, as part of our duties, I do see us reviewing those applicable laws that define and regulate seclusion in schools. And as a director and, person who's just like here for people, that's just like why I wake up every day and do things. I care very deeply about us abiding by the law and acting within the confines of the law, and vulnerably speaking, not, there is a district that I support where there was a case of inappropriate use of a restrictive procedure recently, and we're working through that. And that rising to my attention has changed the way that as an administrator, I am leading my team through that process. We are implementing new accountability practices. We are retraining. We are increasing frequency of training. And so I think this is important because we know that people use these practices inappropriately. We know that there's a wide range of practices that occur not in alignment with the way we train or expect, because it's human beings that are doing these, implementing these procedures in high stress situations. And so as a system, our job is to create infrastructure and networks of support to prevent that from occurring. And I do think that is part of the conversation. And how do we do that better as school systems and, in partnership with, MDE and other entities? How do we do better to prevent inappropriate use? And I see that here. And so I think that conversation has a place to a degree as it relates to regulation and those procedures. So just wanted to share that perspective.
And I appreciate that, and that's what I was trying to get in. And I guess my question to you, and I'm genuinely asking, would it be of any value during a discussion on the inappropriate use of seclusion to hear from students upon which it has been inappropriately used? My concern is that I know that it is harmful. I'm wondering if the effect of these conversations and these heartbreaking examples would overshadow the need to implement safeguards or supports to try to remedy the situation. What are your thoughts on that?
From my perspective, it would pull us away from the purpose at hand, because if, for example, a physical hold was the restrictive procedure in my system that was used inappropriately, we're not talking about the effectiveness of those holds when implemented to fidelity, right? And if we're truly trying to assess the effectiveness of seclusion as it's designed and in alignment with the law, if we're looking at what happens when it's used inappropriately, without that training, without that support, that pulls us into a different trajectory from my perspective. And I would rather have a better, deeper understanding of the effect on students. I want to hear student voice, but when that's used appropriately and within the confines of the law, because that is going to help us analyze the best next step from my perspective. So that's just my lens that I bring.
Okay, that's useful, and that's my thought as well. So, okay, I see your hand. I think Ms. Heiser, you were next.
I appreciate Ms. Woodward's point so much. I have spent my career trying to translate laws passed at a Capitol to people on the ground. That is my bread and butter. And for us to say the law is written this way, and we are only going to look at how the law is written, and we're not going to consider how it might be being used on the ground, to me is a fundamental overstep of the directive to review applicable laws defining and regulating seclusion in schools. Maybe we need to be more clear in the law about what an emergency is, what a seclusion is, what happens when you don't have the right steps in place. And so to me, the question of when is seclusion used within the confines of these legal definitions, and when is seclusion used outside of the confines of the legal definitions, is a pretty big question for me of, do we need to change these legal definitions? Do we need to change the law? Do we need to make it more clear to people what is expected and allowed under what we're doing at schools? So I'm totally, I don't want us to get off track, obviously, but I am totally in agreement with the idea of, like, we need to hear from students who've experienced this, because the other thing is, I don't know too many students who have been secluded who come up and say, that was done within the confines of the law. Like, that was done pretty appropriately. Most of them have stories that bleed in between what was legally defined and what wasn't legally defined. I would like to know if we can do better in that direction.
And Ms. Heiser, I agree with you. I think we do need to look at examples of the misuse of seclusion as a restrictive procedure. I think we need to dig into why that is happening and how we as a legislature can support that and prevent it from happening in the future. And if that involves clarifying the language of the statute or building into other safeguards, that's, I think, totally appropriate, and I think something we should cover. I did make a note of a topic of a future meeting being the inappropriate use of seclusion. And what I'd like to do is a deep dive on why that's happening and how we can support those school districts so that it doesn't happen anymore. I don't think we need to hear the voices of the students for which it was misused. So I think we can explore the misuse of seclusion without going down that other avenue. That's all I'm saying. Next, Ms. Hulse.
I just want to mention that Ms. Christensen, in her remarks, made reference to the MDE, it wasn't seclusion specifically, but the Restrictive Procedures Working Group, and she mentioned it running from 2019 to when it was disbanded in 2025. My experience with that group was actually from 2015 to 2025, and Sue, I think you're the resident historian. I share your concern. That group met for 10 years and went in circles. And I think that it was for reasons that you're describing. It basically became testimony from basically those who were very no one is pro-seclusion, let's get serious. But those who saw the value in maintaining it as a tool, and those who really wanted to demonstrate all the reasons that it was bad. And that became an exercise in frustration for 10 years of my career. And I think for others who held different viewpoints, what I am very hopeful about in this particular room and with this group of people is that we can move beyond that towards something that is more goal-focused. And so no one asked me specifically, but I would tend to agree. I don't think that we need to hear specifically from students in that particular scenario. I think we can agree that it's harmful, it's hurtful. We as educators have heard those students' stories ourselves. We've had to talk to those parents and walk through the hurt that it has caused. We've had to talk to those staff and walk through the hurt that it has caused and ameliorate that hurt. We've lived it. And how can we figure out how to do this better? So, thank you.
Mr. Rappy.
Thank you, Madam Chair. I was on the Pellsby Ethics Committee for 5 years, and one of my concerns about this is if there was something that was done wrong, there's a good chance there's an ethics complaint. And because of the privacy of those ethics complaints, I would hate to have somebody come on public record and give a new testimony that could change that, whether it be a teacher or a student. So that's just one of the concerns I have, and I know with the privacy of the ethics complaints, I don't know if we'd be able to find out if they were in the process or where they are in the process during that. And I wouldn't want to jeopardize a student's testimony, bringing them here, putting them on the public record.
Thank you. And that's a good point, too. I think my interest in this particular topic is to find out what is happening, why it's happening, and how we as a legislature can prevent it from happening in the future. Ms. Abderholden.
I was also going to suggest that, if districts have a seclusion room, it's supposed to be registered with the Department of Ed, so it'd be nice to know which districts those are. We do know that you can still block egress, and that would still be considered seclusion, even if it's just a regular classroom, but that would at least get us into those particular situations, which would be helpful. And the number of complaints, to the department on the use as well. Just collecting some of that information and having it before the committee might be helpful.
Thank you. I know that last session I did ask for a lot of that data. And I did get data. It wasn't good data in my opinion. The list of registered seclusion rooms included schools that were no longer around, Capitol View, for example, which doesn't even physically exist anymore. So I think it would be useful information, but we have to make sure that it's the best and updated information. Ms. Sensor-Mura, or Representative, excuse me.
Thank you, Madam Chair. I think I just wanted to add a little bit about a lawmaker's point of view, because I think, right, what we are doing, right, is trying to make a recommendation that could then be carried out in some way by the legislature. And I think I'm thinking about the best way to harness all the knowledge that you all have, especially, hearing the people who have been very deep in this conversation for years, but does that knowledge always reach the legislature? I feel like it would be helpful for me, and I would imagine some of my colleagues, to be able to hear both when is seclusion used in the right way and when is it working for students and when is it not. We spend so much time at the legislature, talking about the jargon of safeguards, the jargon of belt and suspenders, right? Because we're always trying to figure out what is it that we need to add or tweak to make sure that laws are being implemented in the right way. And so I feel like it is our duty, if the laws are currently, not being interpreted in the right way, is that because of malice or negligence on the part of schools, or is it really that there's something that's actually not clear in the law that could be more clear? And so I don't know if it needs to be student testimony that gets us to that place, but I think that is an important thing to talk about. I wonder if there is a way to just look at some of the data that is around that to see how often are seclusions, being reported that are not being done according to the law. But I wouldn't want to just put so much parameters around that we can't dig into that topic, because I would say that, just thinking back to conversations that I had with my colleague around this bill, maybe there's a lot of misinformation with legislators out there, right? That maybe we assume that seclusion rooms are being misused more than they are, right? And so if that's the case, I would like to know that, but I don't want to not be able to dig into that piece of it. Thank you.
Mr. Sandsmark, over here. Oh, Ms. Sandsmark, sorry.
Thank you, Madam Chair. Just based on the conversations we're having, and I totally understand the idea of not wanting to, get off track or talk about instances that aren't pertaining to the specific way we're talking about the restrictive procedure around seclusion. But with one of our charges being the effects of seclusion on children's mental health, I feel like within those parameters, I'm curious, even if we're feeling like we can't hear from students that have maybe been had to experience seclusion in a way that was not abiding by the law, I would love to also hear from students, or whatever that can look like, if it's been handled correctly, but still, what are the side effects of that mental health? What are the side effects of that use of appropriate seclusion as well? Because I think that's a really important data point for us, and for me, I think for anybody here to understand, to make sure we're understanding the repercussions of even when used appropriately.
And I completely agree, and I would love to have that discussion. And part of that discussion was the basis for the bill that I introduced last session and that passed through the Senate, and that was really kind of the cornerstone of the discussions that we had. How do we protect children's mental health? How do we protect children's well-being while keeping everybody safe? And how can we build those protections into the law? And that's what we tried to do with the bill. So those are absolutely discussions that we need to have. Ms. Christensen.
Thank you very much, Madam Chair. I wanted to come back to a data question, and I'm sorry if I'm taking us in a little bit different direction. But at the beginning of the conversation, one of the points that was made was about the intersection between the use of seclusion and calls to law enforcement. And I'm wondering if it is part of the plan to look at the states that have banned seclusion and to see if there was a resulting increase in calls to law enforcement. It's my understanding Georgia, Hawaii, Illinois, Maryland, Nevada, Pennsylvania, and Texas all have seclusion bans. And I would hope that there would be some data to see if the calls to law enforcement from schools increased as a result of those bans. Is that something that the work group plans to look at?
I think that that would fit within the duties of the working group. And certainly, when we enact legislation, oftentimes we look to other states. What have they done? Has it worked? Has it not worked? Where can we make improvements? I think that a lot of times when you look at other states and the results of certain legislation in other states, you have to take it with a grain of salt, because no two states are entirely the same. There could be variables that are at play that affect the results and the data that you're looking at, but it certainly is something that I think is appropriate to take a look at.
Thank you.
Representative Sensimura.
Thank you, Madam Chair. And I'm just trying to remember the language that I believe the Senate was working on, and forgive me because different body, but if I remember correctly, I think it was you that had an amendment that was related to parental consent for seclusion room. And I think, knowing that that's an idea that is out there about a way to amend the current legislation, I wonder if it might be helpful to dig in a little bit to how the talking about seclusion rooms and parent education might look as part of the IEP process. I know from conversations I've had, some concerns that have been raised around that amendment is, just more broadly with the IEP process, right? Like, what is the role of advocacy for parents? What is the role of education? I think we certainly hear from parents who say the IEP process can be very overwhelming. And so I don't always feel like I can be the advocate for my child that I want to be, because I'm coming in, I'm meeting with experts, and so I'm often just saying, yep, that looks good, right? And so I do think there was a concern of saying if schools are presenting a seclusion room and telling, families, we think this would be good for your child, how often are families going to say, oh, okay, actually, no, I want something different, or I'm really feeling like I'm able to make that choice in a very nuanced way. And so I wonder if we could have, I don't know what that would look like and who might be best, but just to kind of be able to hear from that perspective of what kind of education would parents be getting about seclusion rooms, what would that look like as a conversation, part of the IEP process, and hearing a little bit from parents about that process, I think would be helpful. Thank you.
Thank you, Representative. And yes, we had many conversations along those lines as we were drafting that legislation. I'd be happy to put that before this working group so that we could dig in those various ways. Part of what we did as safeguards is that the parents had to actually go and view the seclusion room and talk about the different means of escalation and how the de-escalation happens beforehand, the processing happens afterwards, but seeing it, viewing it with your own eyes was written into the statute. Providing or having the meeting in the parents' native language, if they were not confident in their English skills, and having someone there to support them during that process so they don't feel overwhelmed or pressured to sign off on something that they don't fully understand or don't feel the ability to put up any kind of resistance, was written in. Having specific sign off by the parent. A lot of times for an IEP, if you don't, you get it in the mail, you don't sign it within 30 days, it's deemed a consent. No, they have to specifically sign a separate consent that's in their native language, either written or oral, translated to them so they understand. Specific separate written consent. And then if seclusion is used more than 2 times, I think is how it was finalized in the draft, there's a new meeting to review. So we did build in a few things, but I'd be welcome to the input of this particular working group on how we could make that better, how it falls short, or have those conversations. Who's next? Okay, Ms. Woodward.
As we've continued this conversation about, what lens to take and, thinking about inappropriate seclusion, appropriate seclusion, the effect, I would be a poorly licensed school psychologist if I didn't start thinking about this through the lens of a problem-solving process. And, anytime we think about when something occurs that we're not expecting or wanting to occur, why? Why is it occurring? And I don't think there's anyone around the table who would disagree that there have been instances of inappropriate use. And so going further into those specific details of the inappropriate use, I don't know that it will pull us closer, but unpacking the why did that happen, I do think will help the committee better understand how to prevent inappropriate use and harm to children in the future. And so I think about opportunities, through this working group. I think about our professional organization, my own willingness as an administrator to be vulnerable and say, yeah, there was inappropriate use of restrictive procedures in my system, and here's why. We had a seclusion. We don't have a registered seclusion room. The reason is everyone panicked because there was serious harm and they just did the best they could in that moment. Or this other situation where we had very negligent staff who disregarded their training, and then what happens? But I think us thinking through what other ways, what other data sources could help us tell that story and really understand the root cause of inappropriate use of restrictive procedures may push us closer to a solution. And I would be, happy to have further conversation on what that could look like and what data would be meaningful, valid, and reliable.
Thank you. Next. Ms. Abderholden.
So I have looked at the other states and things like that. And one thing that we discovered just talking to my colleagues at other NAMIs is that there's a lot of information that is not reported. So How many times police entered a building? That's not reported generally. How many kids had to go homebound, which is another thing that happens because the school says, I'm sorry, we can't handle the behaviors of your child. Also, there was an increase in kids going to residential because the schools really couldn't serve them. So some of that information, I just wanted to be clear, is not actually collected in a lot of those states. And so so yes, those states did that. And if you think of Illinois, it was like a huge, I want to say, scandal because of the very high numbers. They didn't have a statute that really regulated it or reporting and things like that. So there were different reasons why those states did that. But I just want to caution us that you can't always find kind of the adverse effects aren't necessarily collected. So just wanted to make sure people knew that.
Ms. Sandmark.
Thank you, Chair. To that point, Ms. Apperholden, I'd be curious, though, to look at the reasons why those states did ban seclusion and looking at rates of maybe misuse. That could be important for us to learn here in Minnesota as well. There are still inordinate rates of misuse. The data might not be collected in the right way in a lot of those states, and I'd be really curious, and I haven't looked at that data directly myself, and I would lean towards your expertise on that, of course. But it begs the question to me, hearing that other states have banned it, I'm curious, with the reasons why, and I'm curious about maybe bringing some of that data, even if it's data that they utilize within their own state, what are those metrics that they utilize to make that decision? And I'd be curious if we've looked at those same types of data points here, even just to give us some insight on the use of seclusion and the restrictive procedure itself.
And the converse of that, did those states engage in a educated working group like we're doing right now? Mm-hmm. My concern is, to be blunt, we almost banned it in 2023 and nobody knew it. In 2023, when we were moving at a furious pace, passing legislation right and left, so much of which I am very proud of. During a committee hearing and during conference committee, there was an amendment made to a bill to ban seclusion through grade 3 and to direct the Commission of Education to come up with a plan for the urgent banning of seclusion through grade 12. Nobody brought that to my attention. I'm not on any education committees. Nobody brought that to my attention. We didn't caucus it. Nobody pointed that out on the floor. It was done on the sly. And when I learned that happened, that's when I spoke up. And that is part of why we're having this working group. So I would be interested in knowing, did those bans occur under the cloak of darkness and without transparency, like almost happened in the state of Minnesota? So we can certainly take a look at that data. Ms. Hulse.
I do think we have our 1 year of baseline data here in Minnesota with our K-3 students, and we do have trends that we have started to see. We do know that our physical holding for our K-3 students has gone way, way up. We do know that we've had students in setting 3 be referred to setting 4 at higher rates. We do know, at least within the data that I have access to, we know that in setting 4, we've had to refer our students to the programs with higher mental health supports than our typical run-of-the-mill setting 4 programs. And we do know that we've had more conversations and more movement to programs that are like home-based placements or day treatment programs. So I don't know what Dave has going on over at 916, but we do have our own baseline data. It's only a year, but.
And I would like to see that. I would like to hear the experiences from the districts through grade 3 on what trends and differences they're seeing. And I'd also like to hear from Minneapolis, who has eliminated the use of seclusion in all of their schools. And I'd like to hear more about that as well. I think this is information that we need and the conversation that we need to have as a part of this working group. So I would agree. Ms. Heiser.
Thank you, Madam Chair. I just want to ask a question. I have not seen the data since this last school year. Are you referring to your particular district, or are you referring to statewide data?
Ms. Heiser, I'd ask all questions to go through the chair. So you would like me to recognize Ms. Halsey to respond to your question?
My apologies, Madam Chair. Yes, thank you.
Okay, Ms. Halsey. Halls, sorry.
That's quite all right. Madam Chair, I am speaking to the data that I reported to MDE through conversations I've had with others in similar roles to mine. It seems to be a trend.
Okay. Anyone else? Okay, Mr. Haveman.
Yeah, for what it's worth, I can confirm that from our district, the trend is similar. So since 2023, the durations of the incidents that we're talking about has increased as we are putting more hands on students and having to go more hands-on with students because the ban of seclusion for K-3 has taken hold. And it was some of the staff injuries that have come along with those descriptions that I just described, that drove us to talk to Kate last year about the use of UCARO and having another tool in the toolbox for having to give staff some tools to be able to work with students. So from our data standpoint, the same thing is true.
All right, we've had a really good discussion. We've got a lot of wonderful topics that I think give us a great start to get off the ground. Again, if the members of this working group feel like once a month is not enough, if we want additional meetings, let's be prepared to have that discussion next month. I will have at our next meeting a kind of a list of topics summing up what we talked about here today, and try to make sure that we can allocate enough time through our working group time together to really do a good deep dive into some of these topics and come up with the best data that we can, and kind of all of our brains together, right? Coming up with the best thing that we can for our students here that need additional supports in schools. Our next meeting will be September 17th from 2 to 4 p.m. in this room, Minnesota Senate Building 1150. And there being no further business before the working group, this meeting is adjourned.